Case number 253602 SD. Appearances counsel.
And I'm Jeff Harrison. I'm here with Austin Rakowski. He's joined me at the table.
And it looks like we're here for a couple matters. One is a final pretrial, but I also have an arraignment on an amended complaint. So we'll get that portion done first. Sir, I have an amended complaint that alleges that on or about August 1st, 2025 in Herring Township, it alleges in count number 1 that you operated a motor vehicle while intoxicated. That is the 93-day misdemeanor that you were previously arraigned on. And then there is a new count of operating with a high BAC or bodily alcohol content. That is a misdemeanor punishable by up to 180 days and a fine of $200 to $700 and or 360 hours of community service, rehabilitative programs, vehicle mobilization, and reimbursements for the cost of prosecution and governmental expenses. Do you understand that amended charge and the potential penalties?
Yes, sir.
You do have the same rights that you had available to at the original arraignment, so we will go ahead and enter a not guilty plea on your behalf. We'll continue the appointment of a counsel, and that brings us to the final pretrial. Is there any resolution in this case?
There is.
Any of the defendant will be guilty to added count 3 operating while visibly impaired, and then people will dismiss counts 1 and 2.
That directly comports with my understanding as well, Your Honor.
Mr. Ratowski, have you heard what the attorneys have said the resolution is in this case?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
Can you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. It's my understanding that you'll be pleading guilty to an added count 3 of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $300. Do you understand that? In exchange for that, the operating while intoxicated and the high back will be dismissed. Is that your understanding? Back on August 1st of this year, were you on probation or parole?
No.
Were you on bond? Do you remember reading and signing this advice of rights form, talked about your rights to a trial and your rights to an attorney? Do you understand that you do have the right to have an attorney and the right to have a trial, and by entering a guilty plea, you'll be giving up that right and you won't have a trial of any kind?
Yes.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today? Has anybody threatened you in any way? Is that a no?
No.
And is it your own free choice to plead today?
Yes.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No.
Nor mine.
Then, Mr. Ratowski, to the allegation that on or about August 1st, 2025 in Herring Township of Wexford County, how do you plead to operating while visibly impaired?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on that date, were you operating a motor vehicle in Herring Township?
Yes.
And prior to consuming that alcohol, prior to operating that motor vehicle, had you consumed alcohol?
Yes.
And how much alcohol had you had to drink?
4 years.
All right. And did you believe that those 4 beers would have impaired your ability to operate a motor vehicle?
Yes.
And did you have law enforcement while operating your vehicle? Law enforcement interaction?
Yes.
All right. Do counsel believe that the defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
No.
I concur with that.
As does the court, I find the plea is knowing, voluntary, and accurate. Sir, I find you guilty of operating while visibly impaired pursuant to the plea agreements, operating while intoxicated, and the operating with a high BAC will be dismissed. I have received the substance use assessment, so give me a moment to look at that.
Yeah.
Okay, counsel, have you both had the opportunity to review that?
Yes.
Indeed.
Any additions or corrections?
I don't think so.
No.
All right, allocution, Mr. Harrison?
Well, there's a couple of different things going on here. As you could see, Austin is employed full-time as the 3rd assistant engineer on a Great Lakes freighter. He is contemplating on the 24th, he'll be leaving from Alpena and driving what I understand to be essentially dirt to Duluth, Minnesota on Lake Superior. Despite his employment in that regard, he's maintained appropriate contact with me, and he hasn't had any issues with regard to his testing. I think that shows us his response to this situation. There were some things in the substance use assessment that I don't know what the right word to say is. I don't necessarily think they're red flags, but they were interesting. Well, for example, the fact that he doesn't drink often, but when he does, he has at least 8 beers. I understand the way that looks, but I also understand in speaking to Austin that, yeah, that's usually because he doesn't go anywhere. He's usually at home and, or, you know, watching TV or watching a ball game or something. On this occasion, he had what he described as 4 beers, and I believe him, and was called away by his girlfriend. And as you can tell by the implication, he is often gone for long stretches at a time. So it was probably a unique situation. He did not take the time to assess his ability to properly drive and thus ran into this issue. I would say a couple of things. He doesn't have much experience doing that sort of thing. He has no prior legal record whatsoever. And based on the conversations that I've had with him, there were a couple of things he just simply were, geez, I never realized X or Y or Z. So I'm pleased with his level of inquiry, his level of insight. I'm not sure that that comes across in these, when we read these assessments, they're kind of clinical. Of course, they always seem to mention when they don't believe somebody's being truthful, but if you notice, there's no such nomenclature in this one. So I think he was being honest with the person that, you know, did the evaluation. I think he has a extremely stressful job, and I think his schedule is crazy to say the least. All of that notwithstanding, he's devoted himself to obtaining a substance use assessment, which, again, based on the nature of his employment, was no small feat as well. In addition, he's completely complied with any testing requirements without, I'll say this because he was not the sort of client that was continually whining about how difficult his testing was. He just did it because he knew he had to, and he is a stand-up person who took responsibility. Long and the short of it is I don't know what would be gained by supervising him at this juncture. This has been and will continue to be a painful lesson for him. If for no other reason than he'll be paying his fines and costs as he goes along here. He's had ample opportunity to reflect while he's been at work in the middle of the freshwater sea that we call the Great Lakes. He's had a lot of time to discuss it with his peers and that sort of thing, and come to the conclusion that he definitely should have known better, and he will exercise better judgment in the future. Thank you.
Thank you, Ms. Carey.
Most people say that it's their first time. And I think they believe it. He was a .179 via blood draw. They will be on the lookout for him driving down 131. I don't know where he was coming from, but he lives in Traverse City, so I assume he was coming from there. He made it all the way here. There was open intox in his vehicle, which he was not charged with, but it appears he was drinking in the vehicle as well, and struggled greatly with the field sobriety. So I'm always concerned when a person can get that their BAC that high. That's over twice the limit. It's extremely high. The fact that he's driving at that level is also extremely concerning. And I understand the difficulty with his employment, but I am going to ask for a period of supervision to make sure, just because I think that's warranted under these circumstances. Thank you.
Thank you. Mr. Witowski, you had the opportunity to address the court before sentencing. Is there anything you'd like me to know? So how long, when you go on your shifts, is that a month to a time basically, or?
An average of 28 days, give or take a day on either side, it all depends on holidays.
And are you limited to just the Great Lakes?
Yes.
What is a gate man?
So I'm down in the tunnel, we're a self-unloading ship. So we have a tunnel with gates where the cargo hold the cargo. I open the gate, the car goes up the unloading system into whatever port we're in. And I'm an engineer as well.
Okay. All right. And you had just gone on leave this day then? Well, you'd been at sea, so to speak, for about a month.
Yes,
And then was this your first day back on shore?
it was the first morning, yes.
The first
Got home the
morning.
night before.
Okay. So was you drinking from the night before?
No, I got home at like, I want to say it was like 10:30. Went to sleep, woke up, helped out on my other job. I helped on it. And hung out with some friends. And then during hanging out with friends, got a phone call,
Okay.
which
So what time of day was this?
the incident.
Yeah.
That would have been nighttime.
This was the nighttime,
It was 10.
10 o'clock at night,
It's 10.
but you were drinking earlier in the day.
Yes.
How soon before driving had you stopped drinking? If you had stopped?
I stopped about, I want to say 2 or 3 hours. 4.
And were you coming from Traverse City?
Yes,
And where were you going to?
Cadillac.
Here in Cadillac? So have you had the opportunity to review the assessment?
Yes.
And what are your thoughts on its conclusions?
Pretty accurate.
So at least one of the screening assessments says there's a need for a brief intervention. But it also says that you do not have a substance use disorder. So that bodes well in your favor. I have to admit with Ms. Carey that it is concerning the level of that you were at a 0.179 and having driven from Traverse City to the Cadillac area, although it sounds like not the best, as there was a be on the lookout out for you.
There was a lot of bad driving reported on the DOL. Variable speeds, tailgating completely off the road, crossing the center line, ran off the road.
I had ordered you on random testings. I'm assuming you're on the daily blow machine.
Yes.
How have you found that?
It's doable, but it does kind of inconvenience when I'm out on the ship. Just sometimes I have to stop work, go to a place with the proper lighting. But not.
Well, the assessment says that you're not having any cravings or withdrawals or anything like that. What's your takeaway from all this?
Stay and do what needs to be done to resolve and learn from
What have you learned?
that. Drinking and then driving is not good, no matter. And drinking also impairs your judgment on what you should and should not do.
Anything else you'd like me to know? Well, as we know, there's the presumption of no jail and no probation in these cases. While we do have what is essentially a high BAC, it has been pled down to, operating while visibly impaired. I do have someone who does not have a substance use assessment, or I'm sorry, disorder, and has been on bond with the court since the 4th of August with no violations. I do believe some education is appropriate, but I'm not going to put you on a period of probation. I will be honest that had you had any indication of a disorder, even if it was a mild disorder, I would put you on probation. But it does appear, now I realize you're only 23 years old. It does appear that this was a one-time incident, and hopefully it stays that way. I am going to order that you do the alcohol highway safety education class and victim impact panel. When do you ship out next?
As of right now, it'd be next Thursday.
Next Thursday for another month. I'm gonna give you 60 days in which to get that done. There is a $75 crime victims rights fund fee, $50 state minimum fee. Given the benefit of the plea, I'm going to do a $300 fine, $150 court costs. $150 attorney fee. Is there reimbursements requested, Ms. Carey?
Yes, there is 200.
It was a blood draw.
There was a blood draw.
So $300 to MSP for the blood draw and $100 to the prosecutor. In certain cases, they're able to recoup a portion of their costs in prosecuting these cases. OWIs happen to be one of those. So there is a $300 back to the MSP and $100 back to the prosecutor. Is there any jail on this? Oh, there is. A 1-day jail with 1-day credit. Because I have sentenced you to a term of incarceration, even though it's time served, you do have the right to appeal that decision. If you decided you wanted to appeal that decision, could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. Also, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. Do you have any questions for me about your sentence?
So do I continue the daily?
No, you can go downstairs and turn that. Well, they're probably gone now. You can go downstairs and turn it into the probation office if community corrections is not there. You didn't bring it? Okay, so then you'll need to get that to community corrections tomorrow. And then I'll need you to go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. And then does he contact probation?
Yeah.
You'll need to contact the probation office to get figure out how to get signed up for that alcohol highway safety education class. Okay. All right. Thank you. We are adjourned. And ma'am, you're the guardian in this case? Yes. All right. We are here for a final pretrial. Is there any resolution in this case?
No, Your Honor, respectfully, the defense would request an adjournment. Ms. Swatch is having some issues, but the prosecution indicated that they would consider dismissal if she completed a class and take restitution. She's in the process of doing that. She was having a little bit of trouble with the class. So I would ask for an adjournment so we can figure that out. I'm sure the court's aware of Ms. Watch's situation. So.
Prosecutor's office.
Main concern for the people here in this case is restitution, $136.50.
36.50.
So we could have a short adjournment to get that paid. Resolved.
And I'm sorry. Guardian, how long do you think it would take for the restitution? Tomorrow it could be paid? All right, the court will grant the request. We'll set this over for we'll set it for another final pretrial. It's my understanding that we anticipate the restitution to be paid, so we'll see what happens.
Thank you, Your Honor.
Thank you. All right, we are adjourned. Our next call is the people of the state of Michigan versus Isaiah David Eisenhower. This is case number 252869ST, appearances counsel.
Trying to carry good people.
Robert Hartzell from Mr. Eisenhower, who joins me at the table, Your Honor.
And we are here for a final pretrial. Is there any resolution?
There is not, Your Honor. I would ask the court to allow an adjournment. My client is pursuing some options that the people have presented as a possible resolution. For context, he's trying to enroll in school courses, highway safety, things of that nature. He's had some difficulty signing up through no fault of his own. There's email chains to that regard. I do believe that people will be supportive of adjournment, but I don't want to put words in their mouth. Thank you.
Prosecutor's office.
Would. It was a short adjournment, although. The defense that he has tried with Catholic Human Services to set up a class. People frankly have requested the defendant, given the charge to take a driver improvement course. I'm not sure what CHS can do to help in that regard, so I'd ask that he look at an actual driver improvement course. But like I told the defense, I'm not willing to do this for long or again, given the situation. So I believe that's important.
When was the offer extended to take some sort of class? And
Last time we were in court, I believe.
so back on August 28th, it looks like. And Mr. Hartel, when did your client start reaching out for classes?
He did so the next week when he got paid, Your Honor. He took a minute to get the money to be able to do so.
Talk to your client first and then let me know.
So the way I understand it, Your Honor, is he immediately reached out to attempt to do so, but needed the money to be able to pay for it. And then once he did pay for it, the way I understand it, he has paid for it, but he's waitlisted until there is an active digital seat, for lack of a better term for that.
And who are we taking the class through?
List the Catholic Human Services, correct? The highway safety group? Yes, Your Honor.
Ms. Carey, is that a satisfactory course to you?
It is.
All right. Mr. Eisenhower, did they give you any indication as to how long that could be?
They literally sent me I don't know, I don't have the email in front, but the email literally says that they don't have any dates as of right now, that they will reach out to me as soon as they have any. That's all I know.
And you've already paid for the course?
Paid for it,
How much have you paid?
$250.
Well, given that you've paid $250, this is our first final pretrial, right? What I'm willing to do is set this out to the November final pretrial.
It was just last.
It was what?
8/28, a stipulation on the record to adjourn until this final pretrial,
so we
and
have
now
to
we're doing
start.
it again.
Time clock.
It's been since 7:10.
Due to time requirements, I'm gonna have to set this out to the October final pretrial, which is October 16th. Yeah, October 16th. So hopefully you'll be able to get it taken by then. If not, we'll see where we're at.
Thank you, Your Honor.
Okay.
All right, let's talk about that. This session featured 3 very different cases, and Judge Middleton managed each with his usual mix of clear explanations, pragmatic sentencing, and just enough skepticism to keep everyone honest, was Austin Ratowski, who resolved his OWI case by pleading guilty to the reduced charge of operating while visibly impaired. That deal dismissed both the standard OWI and the high BAC count, and Judge Middleton walked him carefully through the plea. Ritowski admitted to drinking 4 beers before driving, with a BAC later recorded at .179. His attorney highlighted his full-time work as an assistant engineer on a Great Lakes freighter, pointing out that he had complied with all testing requirements despite a grueling schedule. The defense pitched him as responsible, honest, and unlikely to reoffend. The prosecution, though, wasn't buying the idea of just fines, arguing that someone with a BAC that high, tailgating and weaving down the highway, needed supervision. Judge Middleton struck the middle ground. No probation, but mandatory alcohol education, a victim impact panel, fines, and 1 day in jail with credit for time served. He noted Ritowski's young age, lack of prior record, and cooperative demeanor, but still underscored the seriousness of driving at twice the legal limit. The next a juvenile defendant whose guardian appeared alongside her attorney. This one was simpler. Restitution of $36.50 was the main issue, with dismissal on the table if she completed a class and made payment. Judge Middleton showed flexibility, granting an adjournment so restitution could be paid the next day. It was a reminder that sometimes these cases aren't about punishment so much as accountability and small steps toward responsibility. Finally, we had Isa R., whose case was still unresolved but carried a clear path forward. His attorney explained that Eisenhower had been instructed to take a driver improvement course but ran into trouble finding an available seat. He'd already paid $250 for a program through Catholic Human Services and was waitlisted. The prosecution wanted to see progress, not excuses, and the judge pushed for accountability, setting the case over to October 16th to give Eisenhower time to complete the class if a spot opened. Middleton was patient but firm, making clear that extensions wouldn't be granted indefinitely. Eisenhower himself confirmed he had made payment and was waiting for scheduling, and the court seemed willing to give him the benefit of the doubt, for now. The overall courtroom atmosphere varied. A young man facing the consequences of a high BAC, a juvenile defendant making amends for a minor offense, and another adult caught in scheduling limbo on a driver course. Judge Middleton handled each with precision, tailoring outcomes to the circumstances while reinforcing the same central theme: accountability first, leniency only when it's backed up by action. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,